Okay, court calls the people of the state of Michigan versus Harold Arthur Bonnell, case number 254238 FY. We are here for an arraignment. Sir, I have a complaint that alleges that...
This is one of those cases that stops you in your tracks. Harold Arthur Bonnell, a Michigan man now facing multiple felony charges involving a minor. The judge's tone says it all. This isn't a misunderstanding, this is serious. What follows is a full readout of charges that could keep him behind bars for decades. Listen closely, this arraignment escalates fast.
Between the dates of March 28th, 2025 and April 15th, 2025 in the city of Cadillac in Wexford County, in count number 1, it is alleged that you committed the offense of criminal sexual conduct, 3rd degree, person between 13 and 15. That is a felony punishable by up to 15 years in prison with mandatory AIDS and STD testing and DNA to be taken upon arrest. In count number 2, it is alleged that you committed the offense of child.
Now that's where the courtroom shifts from accusation to calculation. Every word the judge reads adds years to the possible sentence. 15 years, then doubled to 30 because of prior felonies. Michigan's habitual offender law hits hard. If you've already been convicted before, every new offense multiplies. The prosecution isn't just charging Bonnell. They're building a wall of time around him.
Possession, that is a felony punishable by up to 4 years in prison and or a fine of $10,000. In count number 3, it is alleged you committed the offense of computers using a crime using a computer to commit the crime with a maximum imprisonment of 4 years or more, but less than 10 years. That is a felony punishable by up to 7 years in prison and or a fine of $5,000 with reimbursement for governmental expenses. Additionally, the prosecution has elected to charge you as a habitual offender 3rd offense notice. That means that you have at least 2 prior either completed or attempted felonies in your past. That makes that 15-year felony a 30-year felony, the 4-year felony a 8-year felony, and the 7-year felony a 14-year felony. Do you understand those charges and the potential penalties?
Yes, I do.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to.
This is where courtroom formality meets quiet reality. The defendant calmly says he's on SSI and needs a public defender. It sounds routine, but it reveals a lot. No job, no savings, and no legal support system. When you're this deep in the system, your only lifeline is the attorney the state gives you. And even that comes with conditions.
And you have the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment of an attorney.
And what is your current source of income?
I get SSI and Social Security.
Court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf. Then we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the crimes. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Do you understand that?
Yes, I do.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show in 1996 a B&E of a coin-operated device, 97 B&E of a vehicle to steal over $5, 01 a driving while license suspended, 15 a domestic violence, 15 no insurance. There was a 7411 case back in 95. And it's my understanding he currently has a CSC second case pending in White Cloud. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. We do, of course, respect these are very serious allegations. As the court did note, he is currently lodged, as we can see. I obviously don't know much about that other case, but if I understand correctly, his bond is $20,000. It looks like he figured out the lights there. But
Here comes the bond argument, always a courtroom chess match. The defense paints Bonnell as harmless and poor, hoping for leniency. But the elephant in the room, he's already facing similar charges in another county. That instantly changes everything. When you're already under investigation for sexual assault, low risk doesn't exactly apply.
I believe his bond is $20,000 in that file, if I understand correctly. His attorney, he tells me it's been assigned over there, may or may not be able to work on getting that bond lowered if our bond isn't too unreasonable on our end. As he did note, he is on disability. He does not have any substantial savings. He's not specifically from our community, but he has strong ties to Michigan, at least. I don't believe he'd have any issue with obeying a bond condition of staying inside the state of Michigan, as we most often see. I don't doubt he would also obey other bond conditions, such as no unsupervised contact with minors, perhaps no use of a computer in general due to the nature of the allegations. I haven't read the complaint. I just know these are standard ones that can be used for public safety. But ask the court to keep any monetary bond as low as possible, not only due to his low income, but also due to the fact that he does have a monetary bond where he's currently lodged, and he clearly hasn't been able to post it in the 2 months he's been there. Thank you.
Thank you. Mr. Carnes?
Thank you, Your Honor.
The prosecution's tone here is confident, almost certain. They say Bonnell admitted to the sexual encounter, and they've got evidence to prove it. Images, videos, digital footprints, all tying him to the victim. That's not circumstantial. That's direct. This is the moment the courtroom temperature drops. Everyone knows, if the evidence matches the confession, conviction is just a matter of time.
I would say the likelihood of conviction here seems high. The defendant made admissions to police that, while slightly different than the victim's account, does have certain things that line up and does meet all the elements of count one. Additionally, there was evidence found on his phone to support count two, and as I read it, very possibly also an added count of aggravated possession based on videos that were found on his phone as well. I would ask the court to set a monetary bond in the amount of $150,000 and to have put a no contact order in with the minor child, as well as no contact provision, no unsupervised contact with anyone under the age of 16. Thank you.
Thank you. Mr. Carnes, my reading of the probable cause affidavit is he admitted to the intercourse and to the exchanging photographs. Is that accurate?
When the judge finally speaks, it's firm and final. Bonnell is officially labeled a danger to society. No computers, no unsupervised contact with minors, and if he ever leaves that cell, it's with a GPS on his ankle. The message is clear. The court won't risk another victim, not even by accident. It's complete isolation by law.
Yes, Your Honor.
All right. The court finds that the defendant is a threat to the community. He's facing CSC's second charges in another county. I believe the likelihood of conviction, some sort of conviction in this case, is strong given the defendant's admissions, the defendant's age with a person who is alleged to be a minor causes the court some great concern. I do find that he is a threat to the community. As a condition of bond, Mr. Bonnell, you are to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. You're ordered not to have any contact with the victim in this case, whose name will appear in the no contact order. You are also not to have any unsupervised contact with anyone under the age of 16. You are not to act in any threatening, intimidating, harassing, or violent behavior. If you do bond out, you'll be on a GPS tether, house arrest. I'm also going to order that you not access any computers or the internet or school property.
And just like that, the session ends. Bond, $100,000 cash. Restrictions, total. With another active case and digital evidence stacked against him, Bunnell's future looks sealed. The justice system doesn't forget patterns, and this case shows exactly why. If you found this courtroom moment as intense as we did, hit that like button, share your thoughts in the comments, and subscribe for more real cases where the law doesn't blink.
Meaning elementary schools, high schools, or preschools. Mr. Carnes, is there any reason for drug or alcohol provisions?
Not based on content.
Given the nature of the allegations, the fact that I find the defendant as a flight risk, as I said, he's facing charges in another county. I understand bond down there is $20,000 and he's not been able to post that. The court will set this bond at $100,000 cash or surety. Thank you, Nuego.